The justices of the Supreme Court today entertained applications filed by the Makerere University Law dons and the civil society seeking to join a petition challenging the outcome of the just concluded presidential election as friends of court. Former Premier Mbabazi, who contested President Yoweri Museveni's victory, filed the original suit in the highest appellate court. The law dons, through their lawyers Mulema Mukasa, David Sembatia, and Robert Chirunda, told court that they are neutral but filed the petition to guide court and offer expertise. However, lawyers representing President Yoweri Museveni, led by Ebert Biancha, accused Professor Oloko Nyango and Dr. Businje Kabumba, both who teach constitutional law, of bias.
We have attached articles. Most of those we were able to obtain in the short time were those of Professor Joe Oloka Onyango. The articles make interesting reading, but even the titles of the articles speak for themselves. And so is almost every statement that is made in those articles. We have also an article of Dr. Kabumba. My Lord, an interesting thing is in one, again in a prominent part, he refers to the first respondent as a dictator in a suit. It cannot be said that this person is friendly, certainly, to the first respondent.
The Electoral Commission lawyer Mark Dusman Kabega and Deputy Attorney General Mwesgwa Rukutana also cited bias, arguing that this would breach the rule of amicus curiae. Kabega took a swipe at the legal scholars, suggesting perhaps rather than wasting court's time, they could write an academic paper.
The court has given the timelines for filing the skeleton submissions. So for the court to be diverted into an issue of amicus would be, my lord, to put the court of course.
They are not impartial, sir. They are partisan. It does not matter whether the concerns are legitimate or not, but this is not the correct forum.
Amama Mbabazi's legal team, however, welcomed the application.
We have no objection for the court to have friends who are professors.
The law on amicus is such that the court retains the powers and the jurisdiction to control the boundaries within which amicus may or may not submit. And so the court is empowered to guard against any perceptions of bias, any boundaries that seem to stretch way beyond.
In the afternoon, lawyers representing the civil society legally defended why their clients should appear before court. However, the lawyers of the three respondents, namely the President, the Electoral Commission, and the Attorney General respectively, say the civil society was not independent and were part of the opposition Democratic Alliance. Barely after delivering a verdict on these two applications on Monday, the Supreme Court will in earnest commence hearing the main petition. Suhail Mugavi, NTV Weekend Edition.